Welcome, welcome. We're live tonight and we're ready to go. So, you guys know what we're talking about tonight. Tonight, we've got a very important subject on the table. And I think this eliminate property tax lawsuit package and that situation has gotten more hits than all of my other videos. I think I have 32 videos in the eliminating property tax lawsuit package playlist on my YouTube channel. So you guys can go over there and take a look at that stuff when you get a chance. So welcome tonight to live stream Advocates for Justice Paralegal School. We provide the tools, you do the work. I'm Coach Neighbors, and I get to blow the whistle around here tonight because I've done my homework. So a couple of things before we get started here. I'm going to change the focus of our stream content a little bit to include what's going on in real time with our lawsuit packages, like what we're going to talk about tonight. Tonight, we're going to jump into the eliminating property tax lawsuit package. And we talked about that a little bit. And before we get into that, I want to make sure that if you guys are coming from Facebook, please click on this link and give Facebook permission to use or give StreamYard permission to use your Facebook name. So you guys need to click on that. That way, otherwise, when you make comments, you show as a user, as Facebook user, and I don't know who you are. So, hey, Mike Williams, welcome. We're ready to rock and roll tonight. And as you can see on the screen there, what's up, what the subject is tonight. So tonight we're going to talk about eliminating property tax lawsuits package. And we had a judge trying to dismiss the package, and we're going to talk about why the judge dismissed it and what you need to do about it. But before we get to all of that, there's a couple of before we get to tonight. I want you guys to take a look at the new page for the eliminating property tax package that I put together. And it came out really nice. I put this link in the comment section so you guys can check it out. Yep, we about to roll. We talking about to talk about tonight, so we got it going on up in here tonight. And this is something that affects everybody, unless you like paying for free and you don't need to be paying. Okay. So you can scroll down, you can click on that link and scroll down. Just kind of wanted to show you guys what this looks like. And now I use samcart.com to post my offers on. And the reason I do that is because I can put a whole bunch of videos in one page and still not have it load. If I did that on my website, my website would load really slow with all those videos. So I'm trying to put the main videos that you need to watch in the offer page, so you don't have to go to my YouTube channel and then sift through 237 videos to find the ones you. Now you need to go to the channel and learn how to use it, because it's going to help you tremendously in the process. Now, for instance, there is my videos on my YouTube channel. The first section, the first half of the title is what I put in there, so YouTube will rank my video, rank, and YouTube will show it. The second part of the title is what you're going to be learning or what the subject matter is about. So keeping that in mind, when you go to my YouTube channel, everything is put in different playlists. There's a playlist for controlling the attorneys in court. There's a playlist for how to handle a judge. There's a playlist for tricks and strategies that you need to know to keep them from throwing you out. Using that, because they're not going to throw you out on the merits against my stuff. I'll tell you that right now. Okay, they're not going to throw you out on the merits of my stuff. They throw you out with trickery, with the rules that they're not following, procedural issues, all this other junk is what they're used to try to throw you out. And you know, our Facebook group are actually groups, because we have one for the lawsuit packages. We also have one for the online course, one for the paralegal school. So the Facebook groups allow us to get real-time feedback about how these fools are trying to get around or whatever. And it allows us to change the program, add stuff to it. And then, so a lot of people think the Facebook page is where you can go and meet with other people. And no, it's not really working out like that, because I can't have other people giving out advice. And you know, a lot of times people get excited. Some people like to hear themselves talk more than me. Okay, anyway, so you know, the problem is I don't want people telling people what to do, and it's not for me or it's the right thing. So you can see where that would create a problem. But what we do use the page for is communication. People will come in and they'll, when you, I don't really like to talk to people on the same day they get something from the court, because it looked like this kid on the picture right here. And they need to breathe in a paper bag. It works out better for me to talk to people after they figured out what they got, after they researched it, Googled the document they received, figure out what they're trying to do with the document, figure out how they got around your document to come up with their document, yeah, and what your game plan is going to be. And then you can message me in the group, hey, this is what I got. You just tell me the title. I already know pretty much. You tell me the title, and what you think it's, you know, and what your game plan is going to be. Now, as a group coach, I have something to go by. I have a little bit of understanding of where you are, what you understand. And that helps me be able to coach you, because I can tell you, oh, brother, you know, you'll be like, what? Because you don't understand that, you know. And I'm not an attorney, so I don't tell people what to do. But you figure out what your game plan is. I'll tell you if it stinks or not. So this is what I put together. Now, the reason I'm showing you guys this out the gate, because this is what we're going to talk about. And as you can see right there, I put a little, figured out how to put a picture of it in the website, so people in the page, so people can see what the front page looks like. So people can see we coming with fire. And constitutional violations, I left that open because I'm not even going to narrow it down to the couple or three that actually that I used to start this with. You know, after learning a little more about due process and all of that, with this constitutional violation thing can be a page long with what these people are pulling on you guys. So this gives you an idea to see what the lawsuit title is about and what you're going in with, because some people have a problem with this. Some people have a problem. I had a lady tell me, well, sue the judge? Oh, no, I couldn't do that. I'm like, ma'am, well, you should not get in my program, because, yeah, I stopped short of telling her she probably should just go and pack her stuff, because the judge is the one that's going to help them in the end. We're finding that out in all of our Facebook groups. The judge is the one that's going to help them in the end. So I actually have a new package that I put together to address the judgeship ship, SHIP. Okay, I'm just talking to YouTube so they don't start flagging me if I say too many bad words. So I actually have a lawsuit package that I put together that you can handle the judgeship at the beginning of the process and just sue the judge out of the gate for unrelated stuff. Yeah, and it's called the eviction stopper. That's the first part of the title. The second part of the title is a jurisdiction challenge lawsuit with affidavit. And we'll get to that affidavit part and why we do that here in a little bit. So I'm just gonna go ahead and stroll all down. You guys have been following me for a while. You know I love my bombers. And I got a bunch of them and I love to use them. So yeah, I got a chance to stick one of them in there. So Mike, no, there's no updating for old purchasers, Mike. My program changes all the time based off of real-time feedback that I get. And the thing is, what you got's working. Most people are worried about updating and haven't even used what they have yet. So no, I don't do that. I would be running around crazy, and I'd have to have another whole department just for updating stuff that people bought a year ago. So I had Mike, at one point I had, when I first started this lawsuit package out, at one point I made 3 changes in a week to the non-judicial foreclosure defense lawsuit package. And yeah, the people that were using it were like trying to pull out their hair. But hey, I tell them you don't have to. You don't have to make the changes if you don't want to. Good evening, Troy. So, Mike, this is stuff we can talk about some other time. I'm trying to get through what we got here tonight, and what you're talking about here is not really going to help everybody. So, except for everybody knows that I'm not going to be going backwards trying to get new stuff and whatever. What you have, it works if you use it right. So that's all I got to say on that. So I have this on sale for the length of the stream tonight. I have it now. Here I'm putting in the training videos. So I still have a whole bunch to go. So I just already got started with the ones I thought people should be looking at first to make sure. These are the general reasons why they try to throw your stuff out. So we're going to throw those videos on here first so people can read them and know how to state a claim and know how to respond to the answer and those things. And those are all things that you have to learn on your own. But fortunately, I address these things in my videos. And this is why it's so important to spend time watching the videos, especially if you're filing stuff in court or new to doing this. The tricks and tips and strategies that they use controlling their attorneys in court, playlists like that are priceless for you to learn, because when you go to the clerk, they're going to be and telling you a bunch of lies, trying to get you to believe that what you're doing is crazy. I had a person who invested in my marriage dissolution document, where you can actually file this document on the public record and dissolve your marriage. And you're dissolving your marriage doing the same thing that they do to make it legal, placing it on the public record. But they charge you for a license and all of this stuff to get married. And then when you want to get divorced, okay, unmarried, we don't use the D word. When you want to get unmarried, they try to make you get a divorce where you have to go to the court, pay attorneys, and pay all these fees and jump through these hoops and get it dragged on and on and on. It's absolutely crazy. And in the end, they're going to place the final document on the public record for $10. And if anybody wants to check and see if you're married or not, they can go and check on the public record. And they don't have to pay to see what you paid $10 for. And the guy went to use it, and they were trying to give him a hard time. So I reminded him that we had that problem before, so we made an adjustment, and we put in there that lawsuit that we use in the eviction stopper package to sue the judge or the clerk or a corporation. You can sue any or all three. Yeah, so yeah, he's going back to refill that out. So he said the clerk had never heard of anybody dissolving their marriage. He said, "No, I'm not trying to get a divorce. All I need you to do is place this on the public record, and here's my $10." Yeah, she was freaking. She didn't. Yeah, they didn't do it. So he's going back with a little more power. With a little more power this time. He's going to fly the bomber in second time around. In my satisfaction, I stopped giving 100% guarantee because I have people ripping me off with credit card scams. So what I do now is, if you can prove that the stuff that I have in my package is not factual, is not as inaccurate, then I'll consider refunding your money. That's where we're at with that. At the end of the day, when you get to download, it's a done deal, and it's not fair to me. I provide plenty of videos, instructional videos, 237 videos to watch of what I'm talking about and what I'm doing. So you should have an idea before you click on that buy now button or the invest now button at the top. You should already have an idea about what you're getting in for. And then there's a little bit about me and a little bit about why I do this and what we're doing. And then there's a checkout. Oh, it's not showing $500. It's marked down. Huh. Wonder why it's still showing $600. Well, we'll take a look at that. Maybe I forgot to save it. No. I'm telling you guys, the deal's a deal. It ain't the deal yet. Okay, now I think it's saved. Anyway, when you guys, let's see if I can. It should be $500, like I said. Okay, there we go. Okay, I'm a man of my word most of the time. When I'm not, I have no idea what the hell I'm doing. I'm just going to throw it out there. About the computer stuff. Okay, I know what I'm doing about the other stuff. Y'all know that. So easy. Okay, so the next thing I want to show you guys while we got the screen share open is somebody contacted me and told them that the judge, is dismissing the lawsuit. Now they didn't tell me it this way. I would just tell them that I don't know what I can't help you. But to keep it short, they told me the judge was dismissing it, his eliminate property tax lawsuit package, and told him in open court that as long they had his deed and he has jurisdiction. So that was it. So that's how we're going to talk about that. So one of the things that I told people to look up the statute for your state to see if there is a statute that forces people to file their deed and register their deed in their office. So, and I put that in one of my videos, one of the videos I posted on Facebook. So somebody sent me this statute here of the Georgia Code, and they just sent me the statute. They didn't say anything, so I wasn't really sure what the hell they're talking about because, well, so we're gonna chop that up first. So first of all, if people have done their homework, they will know that a code is not a law. A code is not a law. In order for something to be a law, your state constitution, with an exception of Georgia, the Georgia state constitution, and one other state, but I haven't figured out which one it is. Their state constitution doesn't mandate it, but the federal constitution does. At any rate, it's the same. And the state constitution mandates for something to be considered a valid law, there has to have three. It has to have three elements. It has to have an enacting clause, which tells all of the people from what authority the law came from who's subject to following it. It has to have a title, and it has to have a body. And these codes and statutes do not have enacting clauses. They don't have titles, and they don't have bodies. And these elements are supposed to be with the law. So, and I tell people this. Some people just wonder, could it be so simple? Yes, it could be if you take the attorney shit out. You take the attorney crap out. Codes and statutes are not laws. Nope. They're codes and statutes. In order for something to be a law, it has to have an enacting clause, it has to have a title, it has to be passed by the legislature, it has to be in harmony with the Constitution. Oh, wait, there's that. Now, there's a lot of laws that are not in harmony with the Constitution. Oh, wait, not too many. Most of them are codes and statutes. So if a code and a statute is not a valid law, then how could it give the court jurisdiction? It can't. Everything that we learn here, that you learn here, is based off of jurisdiction or the lack thereof. And when you understand that, you will understand why we don't need to talk about all of those things that happen and how many services and all that stuff, because we're not going to be talking about that stuff they want you to talk about. Dude, who's done well in court when you went to court and talked about what they wanted to talk about? Okay. I'm just saying, nobody does well in court when you go in and talk about what they want to talk about because you're on their program. So codes and statutes, they're not valid laws. They do not contain the three elements that are necessary to make it a valid law. So what does that mean? That means that that in a judicial foreclosure or non-judicial, but we'll just go with judicial because it's simpler. There is a law or a statute that they use to start to, yeah, it's a violation of the Constitution. It is a violation of the Constitution because the code or statute does not have the necessary elements to be considered a valid law. End of the story. But I haven't heard one person say, "Hey, I used that," and oh wait, sure, they're gonna throw it out. Are you kidding me? You think they're gonna say, "Oh, dang, you're right, man"? Oh no, 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 no. They're gonna play it to the end and make you sue their butts. That's what they're gonna do. They're gonna play it because they're gonna play the odds. The odds are 95, 98, 99% of us can't afford attorneys, so they have a 99% chance of winning and kicking our butt and talking crap the whole way. Or at least they did. The odds are a little lower now. Well, yeah. So this whole foreclosure thing, if the statutes are not valid laws, they haven't been now. I haven't checked all of them, but the ones that I have checked do not have enacting clauses, do not have titles or bodies. No, they're codes in a book. They're basically policies and procedures for the corporation, and that's it. So let's get to this. They sent me this over, and he's trying to prove that this is the law that makes us register our stuff in their office. And I'm like, no, this is not. If you read this, you let me know where it says that we have to that we must register our property deeds in their office. Yeah, this is written in real tricky in words, and basically what this is this gives their state agency authority from them just to process stolen property deeds. And so this gives them, this doesn't say anywhere in here that you have to do it. They make some reference to the priority of your recording takes and all that. Back in the day, people registered their property. They didn't register their property in the county clerk's office. They went down and and had their deed notarized, and they kept at home in their Bible. And if somebody wanted to step up on them, they had to come to the table with a deed that was notarized, obviously prior to that. It was simple. When now? I love your name. Welcome. you in the right place, man. Or what, man? Anyway, so yeah, it was simple back then. You didn't have to do all this stuff and register your deed in their office and do, and people look, this eliminated property tax lawsuit package is really not about eliminating the property tax. It's about getting your control of your stinking deed. That's what this is about. But if I ask you, hey, would you spend $600 to get control of your deed? Most people are telling me, I do have control of it. It's in their office over there. They're taking real good care of it. And by the way, they raised my property tax. Yeah. You guys know how that goes, right? And the problem is real estate deed fraud. That's the problem with the mortgage fraud. It's not mortgage fraud. It's real estate deed fraud. You got to start with the fraud at the gate. The gate fraud is what you need to call the whole thing. Okay. It's real estate deed fraud. Most people don't realize that each state law mandates that you are to deliver the deed after the sale, but that's not what they do. They didn't deliver your deed to you. What they did was their constructive delivery, and they registered the deed in their office, and they sent you a copy. And it's actually against the law to make a copy of a security from my studies, and then they mail you that copy. That's what they do. Hey, Natalie Barnes, welcome. So when they mail you that copy, you got the copy, and they got to, wait, the Constitution mandates not once, but in two different places that that you can't tax private property. Oh, well, they have a plan for that because when they take your property deed, they register it, they reclassify your property as residential, commercial, or agricultural, one of their commercial classifications, and then they start property tax and start zoning, coding, and all this other stuff. That wouldn't happen if your deed was not in their office. Now, I have people tell me, attorneys come on my Facebook ads and tell me I'm crazy, and I tell them, you know what, dude, I play football and I boxed in college. Okay, those are two things that not smart people do. So I have to keep things simple. And the way I see it is the real estate deed fraud started because the deed was not delivered as mandated by the law, and it was registered, and you were not provided full disclosure. So if there's no law that says you have to put your deed in their office, you should be able to just ask for it back, formally request it back, and have them give it back to you. The property tax is not your problem. I mean, think about it. The property tax is not your problem. Your problem is they have control of the deed to your property, and there's no law that says that they get to keep it. So when people ask me all the time, so how many have you win? I tell them, look, I'll let you know how many wins when you let me know if there is a law in your state that forces you to register your deed in their office. And when you can tell me yes or no, then I'll tell you. It'll be simple. At the end of the day, how this works for you is going to depend on if you're willing to do whatever it takes, because they ain't going to be happy. At the end of the day, there's no law that says you have to put your deed in their office. So you're agreeing to their BS that you're dealing with. Oh, wait. And then they think they have the right to foreclose on you and kick you out if you can't pay this year. But you've been paying for 20 years. How's that work? Can I get an amen? Okay, sorry. So let's turn that off. You guys can go and check this out if you want to. So these things that you're able to access, this is not any kind of a law that's telling you that you must register your property in their office. All this is guidelines allowing the person that they use and that they're using and to be in charge of taking care of your stolen property deeds. And for the people who believe that this is what they have to follow, is for them too. And that's a lot of us, because no one's ever looked it up. Everyone's just been told, oh, the attorneys tell you that they have to register your deed so they can make sure that nobody gets on, on your deed. But here's the thing. Most people have no idea who filed the first illegal lien against your property. The first illegal lien that was filed against your property. Think about it. I'm hoping someone will tell me. I'm waiting. Does anybody know what the first illegal lien was that was filed against your property? The first illegal lien that was filed against your property was the mortgage lien. Think about it. Now, remember, I told you that I'm not that smart, so I have to keep things simple. So if there were several people that owned property, okay, if there were like 3 owners that signed them, in order for that mortgage lien to be signed, all of the owners would have to be present to sign, right? Right. I'm going to just talk back to myself. So the fact that the lender accepted your signature on the mortgage lien proves that you own the property. If you did not own the property, someone else would have had to be there to sign. And I'll tell you right now, this confuses people, and people tell me I'm crazy. The alleged electronic credits that they use that they're calling the mortgage loan was created with your own signature. They turned the promissory note after you signed it. They turned the promissory note into a security they stamp pay to the order of on it, and the vice president or something from the bank signed it, and they process it through the Federal Reserve. So the bank don't have any stake in this at all. All they did was act as a money exchanger. Yep. It was recorded at the courthouse. The first illegal lien was the mortgage lien that you filed against your property. Because if there were other people, the fact that the lender accepted your signature on the alleged loan shows that you're the owner of the property. Hell, if you look at the damn promissory note on the back where the signing page is, you're the only one that signed it. Nobody from the bank signs anything ever. Check. You can go check if you want to. I've been doing this for a minute, and I'm gonna tell you right now, nobody from the bank signed it. And the biggest mistake, let me go ahead and turn this off now. So the biggest mistake I think that most homeowners make in foreclosure defense is thinking the lender is the one coming after them or the servicer. And it's not the lender or the servicer coming after you. When your property goes into foreclosure, you are being attacked by third-party debt collectors, attorneys acting as third-party debt collectors. Now, everybody knows that in a corporation, you have a process that you do at the end of the year or at the end of the quarter or whatever to zero the books out. And that process called charge off. And you claim it on your taxes, you write it off your insurance. Yep, that's the charge off. The GAAP accounting principles do not have any entries for additional income after the charge off. After the charge off, that is it. Oh, they say, oh no, that's not what I Googled it. I should start packing. Okay, yeah, okay. Well, I tell her I did too about 100 million times. So I'm pretty sure I Googled it more than you. But that's a charge off. And after the charge off, that's it. So then the third party debt collectors are brought in too. Yeah. I haven't quite figured out how it circles back around and gets back on the, but you know what? My sister's property that I've been following, they came out of the woods and tried to get a sell again. And it's obvious we started looking on the internet, and your house is already listed for sale long before the foreclosure was even done. Your house is already listed for sale. Yeah. Yeah, we're going to address that issue in the next paperwork that we write. A conspiracy, because the more people you add in, the corporations that know that things are dirty, they don't want to be involved if they know that it's a little hot in the kitchen. And that's how we do things. So let's just move on here. You guys make sure that you subscribe to my channel and click on the ads so that I can get paid for all this free information that I'm giving you guys. It's kind of funny because these attorneys come on Facebook and they try to call me a scam. And I was like, okay, so how can I be scamming when I'm telling you exactly what the deal is? Okay, you can go make your own documents if you know how to do them with what I'm telling you. Or you can go to my YouTube channel and you get the information for free. So no, there's no scam. But and if you, and I have a lot of people, it's really, really rewarding to have people that will message me or email me, hey, I've been using your stuff and I actually got it stopped. We're still in our house. Or yeah, that's pretty cool. And that's what I'm here for. At some point, everybody's going to be watching my YouTube channel, and then YouTube's going to be paying me $100 billion for all the ads, and then I can drop my prices down really, really low. So yeah, so that's kind of where I'm going with that. So you guys just bear with me here. Click on those ads, subscribe to my channel, and make sure that you click the like button. When you click the like button, that lets YouTube algorithms know that people like my stuff, and they'll show it to more people, which means, well, yeah, I get closer to that 100 billion Well, at least I'm getting 100 billion from YouTube and not you guys struggling to stay in your house. And that's one of the beautiful thing about my program here. So I dream big. Oh, also, you guys make sure you share my videos on social media. Just stick them out there so people can see. A lot of people, if they're facing this problem, they're not going to want to say a whole bunch about it or whatever. So we want you guys to put it out there so people can see that there's somebody doing something that's unheard of and they're real and they don't play. And they like having people, they like teaching people how to kick attorneys' butts. Now, tonight we're going to cover the eliminate property tax lawsuit package and where do you start? So the attorneys can't respond to none of my lawsuit packages without and so the judges are helping them. That's why we started focusing on packages with documents that's going to help people with this problem. That's what we do here. We figure out what the problem is, and then we figure out a way to take care of the problem. And so that's what we're doing here, especially with the new package that we came out to sue the judge at the gate. That package has been used for traffic tickets. It can be, and it's only like 150 bucks. I put it for 150 bucks just because I could. And I did. That package can be used. I know it says eliminate property tax lawsuit, or it says eviction stopper on the front, but dude, like I said, you need to look past that. Okay, that's what I use to get my stuff out there. Look past the lawsuit on the other end. That package is the bomb. Now the judges are trying to help them, so we're putting together stuff that we can use to jump in the judge's face because we ain't playing, and what they're doing is not right. So and file an appeal, and a guy telling me that I was about ready to make him go sit on the bench. If you got to appeal, you should be suing. Okay, you appeal in their program. Okay, and our program over here, you sue their butts. You sue when they screw. Okay, sorry. Let me stay focused. I was thinking about that when I actually wrote it down too. It's a nice little. People are wondering when you know. No appeal. You want to sue them as soon as they take advantage of you. Now, what we've got is the information the judge's order to dismiss. And what the judge stated in court was that as long as the judge stated, they have your deed, I have jurisdiction. That's what the judge said. Now you have the door open to complain about the property deed because they violated state law when they didn't deliver your deed like they were supposed to. They violated state property transfer laws. Now, if it's priceless, if you know the facts, the facts are, yeah, judge, you're partially right. They do have my deed, but my legal team, you blame everything on your legal team because we're stupid. We don't know nothing. So blame it on your legal team. My legal team is letting me know that the reason they have my deed is because they registered it violating the state law. They didn't deliver it to me as mandated in the state law. They did what they call the reconstructed delivery and registered in their office. And they made me think that was part of what needed to be done. So they didn't provide me full disclosure, and then they registered my deed. And then they started charging me property taxes, zoning, coding, and all of this stuff. And so I'm pretty sure there's a law against filing illegal lien, because the mortgage lien was illegal, because the fact that they accepted my signature on the promissory, if they accepted my signature on the mortgage against the property, shows that I owned it already, and nobody from the bank signed any of the document that they're saying it's the contract. Yeah, it's priceless to know the facts. So I would be like, yeah, and your judgeship, they violated the state law when they didn't deliver my deed, and I didn't realize it, but my legal team has informed me of it now. So I would like to file oral motion to have you order them to deliver my property deed as mandated by the state law. And then we don't have a problem here. Because if I have my property deed in my Bible, not only will they not be able to charge me property tax, but I don't know. I'm going to throw it out there. If your deed is not in their office, could they prove that you have a mortgage with them? I'm just asking. I don't know how many I won. I'm just asking. So think about it. If they did not have your deed in their office, they couldn't have put the mortgage lien against your property. How does this get back to foreclosure? It's all about the illegal process that they use to get control of your deed, the deed to your property. There's no law that says you have to put your deed in their office. So I don't know. Someone can tell me if they see this differently, but if there's no law that says you have to put your deed in their office and you leave your deed in their office, then you're agreeing. Well, let me take that back. And you don't formally demand to have your deed removed and delivered as mandated by the state law, then you're in agreement to their BS. And you've agreed to let them foreclose on you and kick you off your property. Okay. Okay, sorry. I got a little carried away with that. No one would agree to that. But most people don't realize that's what it's going to come down to in the end. And if you stop and step back and take a look at it, you'll see that this whole thing is by design. And that's why it's a whole thing is by design, and that's why they already have your property listed for sale. They haven't even taken it from you yet, and they got wait. So I have people like, well, I'm going to check back later because they said we can do a loan modification. I'm like, oh my God, a loan modification. Okay, and you're in a non-judicial foreclosure. You got 30 days before they sell your property. Now, the most important thing is not blocking the sale. The most important thing is having a game plan to block the eviction process, which if you do that, you can block the sale. But the thing is, you don't have time for a loan modification. All they're doing is running you out of time. Stop and think about it. Why would they want to give you a loan modification if they don't think if you can't pay already because you haven't paid? Okay, let's make it more simple. Why would they give you a loan modification when they already started the foreclosure process and they can take all of your stuff and you can't do shit about it? Why would they want to make payment arrangements when they can take all of your stuff and keep the payments that you made already? They do that all day long. It ain't right. But people tell me that, and I was like, I just bite and I think, well, they're not a good candidate for my program because they're not desperate enough. Oh, Mike's like, can I explain what type of, Mike, the type of letter that you'd write to sue them for the things that I'm suing them for in the lawsuit package? So if you don't know, then you might want to get the package. That's what the package is for. But I'm here to let you guys know what's up. And if you can do this and then you go get it done. But I'm not here to hold your hand because I'm trying to run a business too. So, but I appreciate you. Hey, Jessica in Oklahoma, how are you doing? Welcome to the show tonight. And we're gonna move along. So, I would have let the judge know that they violated the state law, the law that he has jurisdiction over. Yeah. And, judge's statement should have opened the door for you to stomp him or her in the face and demand that he orders the state to remove and deliver your property deed as mandated by the state law that he has jurisdiction over. So anytime, so guys, you never want to go into court or anywhere and argue what they want to talk about, okay? Because they have a plan for that. You never want to talk about what they want to talk about. What you need to do is go in and address the due process violations and other stuff, but we'll keep it there to keep it simple. The due process violations that happen to you because of the court rules and processes and the fraud, just plain and clear, and the fraud. And I would tell you, in the end, it was in the end, at the end of the day, it came down to the facts. Judge said, they have your deed, I have jurisdiction. Most people worry so much about case law and following all these stinking rules and all this stuff, beat yourself to death. And we never even talk about the facts. At the end of the day, if they can't get past the facts, they got crap for the program. Oh, I know. They're going to do whatever they want. Dude, the judge is not going to give you anything. You're going to have to sue them. That's what we're learning. You're going to have to sue them. And until you do, you're not going to get anything done. And that's what we're learning right now. You're going to just have to sue them. Now, I want to talk a little bit about a couple of other things here while I've got everybody's attention. And one of them is well, there's a couple of things. The first one is the jurisdiction issue. Everything that I do here, that I teach you here, that you will learn here is based off of the jurisdiction or lack thereof. Now, if you don't handle that right at the gate, you got crap for the program. For instance, the judge should never be able to rule on your jurisdictional challenge with an affidavit. Okay, that's if the judge is ruling on your jurisdictional challenge with an affidavit, you messed up somewhere along the way and you missed some steps. And I'll tell you why. The judge should not have any say in the matter until after the parties have responded. So you file something, they get the reply, then you get a chance to do your final reply before your final response, before the judge gets to say anything. You get to do the final right. But that's not what they do in court. So you file your stuff. You don't know that they're supposed to have 14 days or 21 days, or you can look in the Federal Rules Civil Procedure and see how many days they're supposed to have, but no one does that. You just file your stuff, and then you go wait and see for the judge to answer. Well, shoot, the judge is laughing. Yeah, I got this. That's not the way it's supposed to go. You file your stuff, and if they don't respond in the amount of time that the Federal Rules of Civil Procedure mandate they have to respond in, then you should be filing your default. You should be filing your default. Okay, so if you watch the video, the instructional video for the package, you would know that they're not going to be able to respond. I tell you that in the video. They're not going to be able to respond by counter affidavit. And when I say they, I'm talking about the attorneys. The judge has no business responding for the attorneys. And this is why we put the lawsuit package together to go after the judge with, because the judge has always been helping them. Yep. The arguing starts, the judge gets to help them. So we go to the table with stuff they don't want to argue about. That's how we do it. So if you got the judge in your face and the judge ordered a sale or any kind of judgment, I don't care if it's property tax or if it's in criminal court or whatever, what you want to do is object. This is how you handle the judge. You object, you file for reconsideration, and then you sue the judge for violating your rights. And all of the lawsuit packages have all the documents that you need to do this. My goal was to put together the package that you need to do everything. That's why when you look in the non-judicial package, you got like 17 or 18 documents in there. And then I added the jurisdictional challenge with an affidavit to it and another zip file. And then that added another 6 or 8 documents in it. Right. I want you to have everything that you need, because I'm not interested in nickel and diming anybody to death, and there's no way I could keep up with that. So I have everything in the package you need. So you object, you file for reconsideration, you sue the judge, and then you recuse the judge. Yeah. And then when you do that, you leave their little ship floating around in amity jurisdiction without a motor, because without a judge, they have no motor. See, what I teach you here is offense. You're learning foreclosure offense, okay? Because we ain't got time to be a defendant and be on defense, okay? Because everybody's been doing that for years, and that's not helping. We're on offense. So you're going to learn now how to jam the judge up, sue the judge, recuse the judge, and then dare another judge to step up. And if another judge does step up, then you can automatically tell them object. And in the interest of justice, they're going to need to move that stuff over to federal court. Yep, they're going to need to move it over to federal court because no other judges can hear the case if you file your claim against one state judge. All the other state judges, they're buddies. You kidding me? Oh, wait. Your documents already have federal court case law in them. I use federal court case law in everything that I do. So you'll be set. You have them move it over there. Federal case law goes in state court. If you know you got the case law and you got the guts to make them shut the hell up and go sit down, but it don't go the other way around. So they're going to have a problem. You get the case moved over to federal court, they're going to have to refile it and do See, what we learn here is how to jam them up with their own stuff. Yeah, that's what we do here. We jam them up with their own stuff. That's how we do it. And if you stop and think about it, you can move any case that's in state court over to federal court, or move to have it dismissed, because these attorneys are considered to be foreign agents. They're a foreign agent. And a foreign agent cannot file a dispute in state court. You can't file a lawsuit against someone in another state in state court. You have to be in federal court. So the case was filed in the wrong court in the first place. So, and the reason that the attorneys have to file the notice of appearance is because they are a foreign agent. So when they try to play no, dude, they file a notice of appearance. My legal team said when they file a notice of appearance, it's because they're a foreign agent. And foreign agent can't file in state court. So this stuff needs to be moved over to federal court for the court to have jurisdiction, because state court don't have jurisdiction between a dispute between a state citizen and a foreign agent. That's not the way. Yeah. Oh, wait. And you can go on. You checked, and they're not registered with the Foreign Agent Registration Act of 1938, where they're all supposed to. Yeah. So, yeah. If you know the facts, if you learn the facts and the documents that you guys invest in from me, you learn the facts, you'll be driver of the bus. I'm not kidding you. You'll be driver of the bus, because when people talk to you on the phone, instead of talking to you about that crap or the crap they want to know, you just go, wait. Dude, you guys were supposed to deliver my deed to me at the cell, and no one delivered my deed. So the person that registered, that signed to register my deed in your office, that's the person I'm suing as the number one defendant on my lawsuit, because that person didn't deliver the deed to me as mandated by the state law. See how that goes? So the idea is to throw what you got on the table and give them time, because they're not used to having their butt handed to them on a platter. So they're going to need a little time to figure it out. Now, if you're not facing like eviction or whatever, then you have time. If you're about to be harmed, then you got to be willing to do whatever it takes. So I have people that have left me great reviews. I have several really good reviews on my review page about property tax. The one girl, Sarah, she left the best review, and later she said she couldn't discuss it with me anymore. So, and it took me a while before I figured out that they're being forced to sign a non-disclosure statement. And that's usually what attorneys do when you kick their butt anyway, because they don't want anybody to know what that you kicked their butt. Yeah, pretty much. So you guys need to remember, we don't have time for no appeal. You're wasting your time. They're not going to give you anything. They want your stuff. And they already took it. They already split up. And this is my opinion. They've already split up the money and divvied it all up. All they're doing now is just the administrative paperwork part. Now, the administrative paperwork part, that most people don't realize that you're not in a court from the Constitution. You're in an administrative court from a corporation. And the administrative court does not have judicial authority, but they take it because nobody knows what to do or how to write. And this is the reason why they don't have to give you any rights unless you sue them for them. Yeah, we have learned how to cut to the chase. We got 602 people in our private foreclosure group where we, do the lawsuit packages and study. I think we have 71 people in our online course. We have a really badass online. Actually, we have 2 online courses now. I have the non-judicial online course also structured now and set up and open for business. I think I have maybe 3 people in it. So it's pretty new. And people are still getting used to the fact that you can't fight. So the lawsuit packages, I don't take phone calls for the lawsuit packages because when I dropped the price from $1,750 to $850 and then again to $500 and stuff, the property tax packages that is on sale right now at $500, but it's at $600 is where it is. The other packages are at $400. Anyway, I'm not able to take all the calls. And most of the people that are calling me, I'm just going to go here, so don't get offended. Most of the people that are calling me and ask me the questions and haven't taken the time to even watch the instructional video. So I don't take phone calls for the lawsuit packages. You can friend me on Facebook and you can message me in Facebook Messenger, or you can email me, or you can get in in our group, depending on the package that you invest in. And then you can communicate in the group with me. That's fine. But I had to cut the calls out because it's just too much. So that's how we do that. If you're an entrepreneur or a property owner and you invest in the online course, or you invest in the sanctioned lawsuit package that I put together against the prosecutor for traffic tickets and stuff, I have entrepreneurs and paralegals who are actually using my products to start their business. If you purchase one of those premium packages, then you can message me and then I'll call you when I can, because usually I'm busy on the same day. That's how we do that. So I don't want anyone to think I have so many people in the lawsuit packages now, I just don't have time to take all the phone calls. And I'm finding out if you watch the instructional video, you learn a lot. And I'm sure there's still a few questions that people have. And I tell you, the Facebook pages I try to post everything in all of the pages. So all of the information that I post is stuff that people can learn from, and so they won't have questions later. Now, a couple of random things I wanted to talk about that people have trouble with. In the jurisdictional challenge with an affidavit, I have the Attorney General listed in there to serve the Attorney General, to provide a copy to the Attorney General. And that messes with a lot of people's head. And I try to tell people, don't worry about that. Just replace the red font with your information and do the thing, because they don't have time to explain it all or to put why. But I'm going to explain why I do that. When we already found out the judge is helping the attorneys, so we need to put together what we need to put together to jam the judge up. We're helping the attorneys, or we just might as well go sit down and start packing our stuff. Okay, so that's what I've done. Now, when you file a lawsuit against a judge, who are you supposed to serve? The Attorney General. So if you got a jurisdiction issue that you're going to have with an affidavit that they can't respond to anyway, I think it's a great idea to make sure the Attorney General gets a copy of it, because the Attorney General is going to be the one that's going to put the fire out after you get done with they don't do the right thing. So that's why we do that. It's all of our stuff. We get ideas. People call in. I have ideas. We put everything together and we come up with stuff. And we do these things because we already know doing it the regular way is not going to help anybody. So that's why we do it a little bit different. So that's why we do that. We want to give the person above them opportunity to get involved. And if they don't, then fine. You can serve their butts the next yeah, the next document on the list, because you have everything that you need to get this done. And, we talked about earlier, the judge should never have a chance to dismiss your jurisdictional challenge with an affidavit. If that's the case, then you missed the steps of defaulting their attorneys. And anytime it's dismissed, you can bring it back and stick it back in his face. Their jurisdiction can be challenged anytime up to 15 years. So there's no res judicata BS that they, yeah. So one of the things that you guys should remember is that anytime that the judge says something ain't right, you need to just assume automatically that he's lying, because she is, because her mouth's moving. And figure out why she's lying and jam her back up. You should always object to any judge's ruling against you, and do the thing that we did with the judge. Object, reconsideration, file a lawsuit, recuse. You got that? We'll figure out what that spells out, and that's what we'll call it. And you can use that against any judge. It doesn't matter. What you're learning here is how to control the process, not answer to their lies. Okay, we're learning how to control the process. When they don't have a judge and their boat's floating around, their process is jacked up. When you file your lawsuit and you add the attorneys as the number one defendant to your lawsuit, because the attorney is the only person that signed that foreclosure lawsuit against your property or the notice of default letter, when you add the attorney and their law firm, that's a problem. Because the attorney can't litigate the case there, they can't do that, and they can't represent their law firm pro se in court. And so here's the problem they have. See, my paperwork has all of these, takes you into all these little problems. Here's the problem that they have. If they can't litigate the case themselves, they can't represent the case they're a party to, they can't represent the law firm that they're affiliated with, then they have to hire an outside lawyer. And that becomes a problem. And that's a problem because if the outside attorneys are doing the same thing, and they're not going to want to get involved in that. Yeah. So now the judge is going to have to let them go and let them represent themselves, represent all of those things that they won't let you do. They're going to have to let them do. Or you're going to have to give back the money. And then, we have the lawsuit to sue them for that. Sue the judge for letting them. So at the end of the day, you're turning this into your lawsuit against them for screwing you over in court with the processes and the judge's BS and the rules. Yep. And that's why I don't have to hear all of those things that everybody usually want to tell me and think I should listen to about synopsis about your case. Is it judicial or non-judicial? That's all I need to know. Because we're not going to address none of that stuff. And the only thing from all of that stuff that you'll add to your lawsuit package for wrongful foreclosure is a copy of the document that shows the signature of the person that started the lawsuit against your property, because that's the person that you're going to sue. So let's see here. Mike has a question. What if the federal court filed your case but are sitting on the summons to send it out to the parties? Well, you could send the summons yourself. You could have the party served yourself. You don't have to wait for the court for nothing. So I don't know. They have ways of getting out of doing things because no one does anything about it. I had one girl, Shamel Maxwell. She had to. I asked her one day how many times she thought she called down to the courthouse. She said she's pretty sure she called almost every day. Yeah, when they answer the phone, hello, Miss Maxwell. Yeah. So you don't have to wait for the court. I went through the same thing when I had two $10 seatbelt tickets from state court, and I jammed them on pretty good. And they kept ignoring me, so I used, this is when I came up with the removal document. All the stuff that you guys are using, stuff I put together for family members or that I've used. And so I removed my two $10 seatbelt tickets from state court over the federal court without paying, because I didn't, in the interest of justice, they had to take them since I was suing the judge. So yeah. And what I did when I sued the judge is just had him serve myself. Had the parties, I paid someone to go serve them. It's really cool because now the court don't have any control over anything. And that's the way you want to do it. You don't want to give the court control of any of your stuff, because they are all working together and they would like to see you go sit the hell down. Anybody else got any questions? Can we just send out the summons and complaint to the parties in the federal district? I don't. Well, it sounds like they're just stalling. So yeah, this is just what I was saying a minute ago. When now I would not I would not allow the court to have any control over my stuff that didn't involve a decision from the judge. So, because what you have here is the clerks controlling everything, and the clerks will tell you you can't file that and you can't do it like this, but most people don't take the time to look at uh, everything so that they understand what they can do and what they're not supposed to be doing. So, but whatever you do, you need to make sure it's in accordance with the federal rules of civil procedure. Those are the rules that you're supposed to be following, not the local rules. The local rules were put together for bar members to use that speed up the process. So anytime the process in court's getting speed up, you're getting the shaft. So that's pretty much, everybody can figure that out pretty much on their own. So you guys need to remember that yeah, Roger Lou, that's pretty cool. And that's what I usually do, put people's name on there in the individual capacity, add them to it. Keeping in mind, the more people you add to your lawsuit, the more work is going to be to respond. I always like to make sure that I have it stated to where I'm reserved the right to amend, and then you can add parties as the evidence suggests. But at the end of the day, what we found, if you start out with the judge or get the judge soon thereafter, you're putting yourself in the best position, because the idea is to just jam up their process. There's no way you're going to win. Well, actually, I say that, and we've had a couple where the judge recused himself in a couple of cases. I had a case with my sister's foreclosure, where the case was terminated, and then they tried to bring it back. And that's when I done some more homework and found out that termination is a final judgment. So after a final judgment, you can't just start filing stuff again. Yeah, they try some dirty stuff when you beat their butt. You just have to stay on top of it. And you have to check when you get them to the Mexican standoff. You have to make sure you check every 3 or 4 weeks, or every week, to make sure that nothing's filed, because that's the only way they can get around my stuff, is by cheating. And they're having trouble doing that because of our network of people. That we get what's going on in California, we make changes so the people in New York don't have to worry about that, or at least they are aware of it and that the change has been made. Oh, nice. Thanks, Roger. Hey guys, that's all I have for tonight. I want to thank you guys for the privilege of sharing your time. And I hope you guys learned something from today. And anybody interested in that package should jump on it. I'll probably leave it open until tomorrow. Yeah, well, the attorneys are running the third party collection agency. That's true. And that's why we sue the name who signed. Like I said, we're not that smart. So we don't have time to figure all that out. Whoever signed is who we sue. And that's the way it's supposed to be. So I'll see you guys in the next video.